Another remedy that is available to co-owners in certain circumstances is the interdict. The question here is, when would the interdict be the appropriate remedy to institute? The interdict would be appropriate where co-owners or where the co-owners use the property or the co-owned property unreasonably. Usually in the circumstances where the co-owner exceeds his or her entitlement to use in terms of his or her share in the co-owned property, would this unreasonable use be present. Okay, in the previous slide, when we looked at the damages claim, we again went into detail around what would constitute unreasonable use. Please transplant that knowledge that we refreshed there, and also where we discussed unreasonable use in detail in the previous narrations, transplant that knowledge about unreasonable use into our discussion of the interdict. Please also refer back to where we discussed the case of Erasmus versus Afrikander and Pretorius versus Neft, because they illustrate quite neatly how the interdict is used in the context of unreasonable use. So what does the interdict do? Or what is the result of a successful interdict? The interdict prevents and halts the unreasonable use through prohibiting the co-owner from continuing the unreasonable use. In other words, the interdict stops the unreasonable use. It also forces the co-owner to use the property reasonably. An example of how the interdict stops and forces is found in the Pretorius versus Neft case. So what is the basis of the interdict? Normally, the co-owner's right to veto regarding the use of the thing is the basis for the interdict. So it's normally in those instances when the minority doesn't agree with a change in use that has been proposed or that has been implemented by the majority co-owners, then what would ordinarily happen is that the minority co-owners would rely on their right to veto to approach the court for an interdict. However, the general instances of unreasonable use could also trigger the availability of the interdict, given that all the other requirements of an interdict can be met in these circumstances as well. Also note that co-owners cannot prevent another co-owner from using the thing proportionate to his or her share. Again, see the court's remarks on this aspect in the Erasmus case. Where the use is unreasonable, only then the second requirement of the interdict would be met, namely that the right has been infringed or infringement is imminent. However, where a co-owner uses the property proportionate to his or her undivided co-ownership share, and the argument cannot be made that there has been an infringement of the other co-owner's rights, because the use, or let me rephrase, because proportionate use is in line with the right of each co-owner. It is disproportionate use that constitutes unreasonable use, and that then would meet the second requirement for the establishment of an interdict, which is that the right has been infringed or that infringement is imminent. This was discussed in the Erasmus case, so please have a look at that. So with that said, what are the requirements of the interdict then?